As we continue from the prior section on REO transactions and practical application, we now move deeper into the legal framework that governs these deals. While the process of writing offers and managing expectations is critical, this section focuses on what truly protects both the client and the agent, understanding the legal obligations, disclosures, and risks unique to REO properties. REO transactions are not just operationally different, they are legally nuanced. In Arizona, a large number of foreclosures occur through trustees' sales, and when the lender takes title, the property becomes REO. At that point, the lender is treated much like a traditional seller, but with important exceptions and limitations that agents must understand. Liability and insurance considerations. One of the most overlooked areas in REO transactions is liability. Many REO listing agreements require brokers to take on responsibilities that go beyond a typical listing, such as overseeing property maintenance, inspections, or repairs. This creates a potential shift into property management activities, which may not be fully covered under a standard E&O insurance policy. Agents and brokers must carefully review their coverage, policy exclusions, and any indemnification clauses required by the lender. This ties directly back to our earlier discussions on risk management. If an agent takes on responsibilities without proper coverage or understanding, they are exposing themselves and their brokerage to significant liability. As is sales and contract reality. REO properties are almost always sold in their present condition. Under the Arizona Residential Resale Purchase Contract, the property is accepted in its current physical state as of contract acceptance. This does not mean buyers cannot request repairs, but it does mean the seller is typically not obligated to make them. This connects directly to earlier sections on environmental risks, including mold and property condition issues. The burden shifts heavily to the buyer to investigate the property thoroughly. Agents must ensure that buyers understand this reality before entering into the contract. REO addenda and contract modifications. One of the most critical differences in REO transactions is the use of lender-specific addenda. These documents often modify key provisions of the standard AAR contract. These changes may include adjustments to inspection periods, limitations on seller warranties, modifications to financing terms, penalties for failure to close, and broad liability disclaimers. This is where ethical decision-making and competency intersect. Agents must not simply pass documents along, they must help their clients understand the implications of what they are signing. If a provision is unclear or complex, the agent should recommend that the client seek legal advice, consistent with AAC R4281101K. Disclosure obligations in REO transactions. A common misconception is that REO sellers do not have disclosure obligations. In reality, a lender seller is still required to disclose known material defects. However, because lenders often lack first-hand knowledge of the property, they frequently do not provide a seller's property disclosure statement, SPDS. In these situations, agents should still advise buyers to request the SPDS in the offer. If the seller declines, the agent should provide the buyer with a blank SPDS as a guide for inspections and due diligence. This ties directly back to earlier discussions on disclosure and risk. The absence of information increases the need for investigation. Lead-based paint and federal requirements. Federal law requires lead-based paint disclosures for properties built prior to 1978. However, there is an important distinction in foreclosure-related transactions. The foreclosure event itself, such as a trustee's sale, is exempt from these requirements. But once the lender takes ownership and sells the property as REO, the disclosure requirements apply. This highlights the importance of understanding when laws apply and when they do not, something that can easily be misunderstood without proper training. Affidavit of disclosure and rural property requirements. In certain situations, particularly with properties located in unincorporated areas, Arizona law requires the seller to provide an affidavit of disclosure under ARS, paragraph 33-422. While trustee sales may be exempt, once the lender becomes the owner and sells the property, this requirement may apply depending on the property type and location. Again, this reinforces the importance of understanding the transition from foreclosure to REO sale. Septic systems and environmental compliance. Another critical area is wastewater system compliance. Arizona law requires that on-site wastewater systems be inspected within 6 months prior to transfer of ownership. While the foreclosure itself may not trigger this requirement, the subsequent REO sale does. This ties directly back to earlier sections on environmental issues. These are not just property concerns. They are legal requirements that must be satisfied prior to closing. Subdivision public report considerations. In certain cases, lenders who acquire multiple properties in a subdivision may be considered subdividers under Arizona law. This can trigger the requirement to obtain a public report through the Arizona Department of Real Estate. This is a more advanced concept, but it highlights how REO transactions can cross into development and regulatory territory. Bringing it all together, at this stage of the course, everything is connected. Environmental risks, disclosure obligations, contract terms, and ethical responsibilities all converge in REO transactions. The agent's role is not just to facilitate the sale, but to guide the client through a process filled with unknowns, limitations, and legal complexities. The most successful agents in this space are those who understand that REO transactions are not easier. They are more structured, more restrictive, and require a higher level of awareness and communication. As we move into the next section, we will continue building on this foundation by exploring additional distressed property scenarios and how agents can apply these principles consistently across different transaction types. Online discussion. Why is liability higher in REO transactions compared to traditional sales? Answer: because brokers may take on additional responsibilities such as property maintenance and inspections, increasing exposure to risk. Why should a buyer still review a blank SPDS even if the seller does not provide one? Answer: it helps guide inspections and ensures the buyer considers all potential property issues. When do lead-based paint disclosures apply in REO transactions? Answer: they apply when the lender sells the property after foreclosure, not during the foreclosure sale itself.